Hello, my name is Mark Watts. I'm a partner here at Bristows in the IT and Data Protection Group. In my hand I have the proposal for a regulation on data protection that appeared in January 2012, and in this video I was proposing to talk about the data transfer aspects of that regulation. In order to put that in context, I think it's helpful for us to think about what the existing restrictions on data transfers look like. And essentially, in a nutshell, what we have is a law that today says personal data, so data about human beings, can't be transferred outside of the European Economic Area unless the protection for it is adequate, and the magic word here is adequate. Now, that's a pretty broad restriction, and some people, when they hear that for the first time, are rather surprised, because there's a lot of personal data around in the world, and there's data transfers going on every second all over the world the whole time. And so how do those transfers fit with this existing legal requirement? And I think the only answer to that is, well, not very well, actually. So we'll have a brief look at the existing requirement, and then we'll move on to see to what extent the situation has improved under the new regulation. So first of all, some terminology. What is a transfer? People use the word transfer in lots of different ways, and in particular sometimes to refer to the sharing of personal data between two different organizations. And that may be fine, and indeed that may be the way the word is used even in particular legislation. But for the purposes of this video and European data protection, it's generally better to think about it in terms of a transfer means data crossing a country border, and that's how I'll be using it throughout here. So what is a transfer? As I say, it's data crossing a country border, but that doesn't necessarily just mean that data is, for example, emailed or transmitted in some way as a file from a country in Europe to, say, the United States. It's a much broader concept than that. And so the question we often get asked is, well, what about if we have a database in Europe and it's accessed remotely from the US or India or the Philippines or wherever? Is that a data transfer? And the answer to that is clearly yes, it is. And so the best way to think about it is to say, well, is the information that the data comprises, is that becoming known in a country outside of Europe? And if the answer to that is yes, then as a rule of thumb, chances are you've got a data transfer on your hands, and you'll need to think about how that complies with this essential export ban for data leaving Europe that I've just described. Well, what if the protection for the data isn't adequate? And who decides whether it's adequate? Well, what we have at the moment is a list of currently 14 countries that's been issued by the European Commission: Argentina, Switzerland, Canada, Australia, the US in some situations. I won't go through them all. It's a small number, certainly. There's far more countries not on the list than are on it. And if data is transferring to those countries, then you may be able to proceed with the transfer in the sense that it will be lawful. Now, having mentioned Canada and the United States, it's worth just also mentioning that for some of the countries on this list of adequate countries, it's a fairly nuanced finding by the Commission, which means it isn't the case that if the data is simply going to that country, it is necessarily okay. It may be that there's a little bit more detail around the requirements, such as if it's going to Canada, it needs to be covered by their PIPEDA legislation, or if it's going to the US, it needs to be within the remit of the US Safe Harbor, or perhaps the PNR agreement between Europe and the United States. So some of them are blanket approvals for the whole country, some of them aren't. It just depends. It doesn't change the fact that it's a fairly short list, and if you're a multinational looking to transfer data from company to company within the group to have shared resources and so on, this list of countries is far too small, really, to enable you to transfer the data as freely as you might want to. So under the existing regime, if you can't rely on adequacy, then you have to look to the exceptions. And there's a handful of these. It's a closed list, as it were. There's the sort of things one might expect on this, such as you can transfer data about an individual if he or she consents. to that data transfer. And there's a bit of detail around the requirement for consent, so it's unlikely to work for employees because it wouldn't be freely given perhaps, and so it wouldn't be valid. It also needs to be a fully informed consent. So on the whole, controllers tend not to rely on consent in certain situations, particularly in the employment context, and equally it's somewhat frowned upon by certain regulators in particular situations. The reason being that if you transfer the data out of Europe based on an exception, such as consent, then arguably, as long as the data is left Europe lawfully within that exception, what happens to it afterwards is not the business of the controller, and essentially moves the data out of the jurisdiction of the data protection authorities in Europe, which means, in their view, it may be unprotected. And so typically what we see, and with this guidance being issued from the regulators on this in 2005, what we see is a strong preference amongst the regulators for solutions to, or exceptions to the adequacy problem that involve some form of ongoing protection for the data, which is why most of the regulators would much rather those sorts of transfers proceeded on the basis of the next option, which is adequate safeguards. And what this refers to is the data controller who wants to transfer the data, having reached the view that he's transferring it to a country where data isn't protected in an adequate way, and then thinking about, well, what else can I do in order to protect the data? And for most controllers, that tends to turn into some form of contractual solution, which is to say, the recipient of the data would contract with the controller who's sending the data over to, say, the US, and contractually would agree to implement certain protections for that data in a way that, if you like, uses a contract to put in place in the US EU data protection for that particular data, but it does so contractually. That's it in a nutshell. And this is not new, this is the existing regime, and since 2001 there have been a range of contracts, EU model clauses, that have been approved by the European Commission that are in fairly widespread use, I would say, amongst certain multinationals as the means of legitimizing their data transfers. And then finally, on the existing regime, just to mention the UK. The UK is different. It's different in a good way, in the sense that the way that the law has been implemented in the UK and the way it's been interpreted by the Information Commissioner allows controllers a good bit more flexibility on this issue. And in particular, it allows a UK controller to form its own assessment of adequacy. So notwithstanding what the Commission may have said about a particular country, if in the particular circumstances of a particular transfer the controller thinks, well, actually, it's fine, the data's encrypted, it's low risk, it's not going to be there for very long, it's all fine, then it's within the power of the controller to reach that conclusion and to transfer the data. And that's something we see UK controllers relying on to a significant extent. So that's where we are, that's today. The regulation is going through the legislative process in Europe, and it's being pretty heavily amended and hotly debated, to the extent where at this stage we don't actually know whether those negotiations will be completed in time for the regulation to see light of day before the European Parliament dissolves in May next year. So it's perhaps 50-50. We'll have to see. But on the assumption that the law does change and these various disagreements are resolved, I just want to go on to talk about, well, what would the future look like on the current text in terms of data transfers? And the bad news is that we still have this rather outdated concept of an export ban essentially being in place on personal data leaving Europe. That is to say, notwithstanding the prevalence of social networks, cloud computing, the explosion of the internet, mobile apps, and every other technology development you can think of, we still find ourselves faced with a law that erects this legal wall around European Economic Area countries and says you can't transfer data about human beings through it unless you jump through the following hoops, and we'll go on to look at what those hoops look like in a moment. Very similar language is used to the existing regime. So the word adequacy features again. If it's not, if the circumstances of the transfer are not adequate, then the data controller must implement or may implement appropriate safeguards. So before it was adequate safeguards, now it's appropriate safeguards. There's not a whole lot of difference, but there we are. It's a difference in terminology. And in the absence of appropriate safeguards, the controller may be able to rely on an exception. And we'll have a look at the exceptions in a moment. As you can see, although very similar terminology is used, the order has now changed. And that's a fairly significant change, I would say, because what it shows is it reflects the preference of the data protection authorities, which we saw in their 2005 paper 114 on this topic, to have transfers proceed on the basis of mechanisms that follow the data with some sort of protection. In other words, that impose obligations even in the destination country. And it's because of that that we see exceptions such as consent, performance of a contract or vital interests or any of the other ones last on the list, because these are the ones that do not impose an explicit ongoing protection obligation on the recipient of the data. So if we look now at appropriate safeguards, to a large extent it's the same as what we see with adequate safeguards insofar as contracts are concerned. So the EU model clauses will continue to be an example of adequate safeguards. Now, having said that, part of the struggle going on at the moment between the Council, the Commission and the European Parliament is that the Civil Liberties Committee of the European Parliament have proposed that actually these existing solutions, such as model clauses, such as safe harbour, should be reconsidered 2 years after the regulation comes into effect. But putting that to one side, the notion of there being Commission-approved EU model clauses would still be an example of what is now called, what will be called, appropriate safeguards. In addition, there is the possibility of a data protection authority in a particular country itself issuing standard clauses. If the data transfers covered by those clauses affect other member states in Europe, then there would be a need for those clauses to be looked at as part of what's called a consistency mechanism, which is a means of cooperating between the countries. But they could still ultimately be approved as a standard. Now, if a standard set of clauses are being relied upon to put in place appropriate safeguards, whether they're standard and approved by the Commission or by data protection authorities, then no further approval or authorization from the data protection authority is required. And that's a big improvement over the regime today, I would say. If, however, a more ad hoc arrangement, that is something specific to a particular controller or particular transfers for a particular controller, if that's being a contract is being relied on in that situation, then that is something where a permit or an authorization from a local data protection authority would still be necessary. Now, the other aspect of appropriate safeguards, and this is a new aspect that's included in the current draft of the proposed regulation, is the idea that appropriate safeguards could be implemented using non-binding legal instruments. In other words, a non-contractual solution, something else that in all the circumstances is or should be considered as putting in place appropriate safeguards. And it's pretty general, so there's probably a reasonable amount of flexibility as to what that might be. For example, it could be perhaps super strong encryption or something like that, a technical solution rather than a legal solution such as a contract. And in that situation it may be that there's enough there that the controller can make the transfer on the basis of appropriate safeguards. The other possibility that exists today, but as an example of appropriate safeguards, is that of binding corporate rules. So as I say, it exists today. A number of organisations have had their internal compliance programs approved as a means of transferring personal data within the organisation all around the world. That isn't explicitly recognised in the law today, but under the proposed regulation it would be as a specific example of appropriate safeguards that are put in place. And that's obviously a positive thing. the existing mutual recognition and cooperation procedures for the approval of binding corporate rules is still very slow, relatively painful. As a process, it really doesn't work terribly well. So streamlining that in some ways and recognise it under the regulation would actually introduce all sorts of advantages compared to the existing regime. And so the regulation sets out the process by which the lead authority would approve it on behalf of all of the other authorities, and includes a checklist not dissimilar to the checklists we see in papers 153 and 154 and 155, setting out what are the requirements for binding corporate rules. The other development is there is the possibility of binding corporate rules being implemented not just by controllers, which is what almost all so far have covered, but also by processors. So there is the possibility of a large IT provider or cloud computing company having its operations and its network of data centers being approved under binding corporate rules so as to free up transfers within that environment. And then finally, onto the exceptions. So the vast majority of them look the same and unfortunately as narrow as we see under the existing regime, but there is a new one. And that allows controllers who are processing data for their legitimate interests, which is language we're familiar with under the existing regime, to transfer data lawfully if it is neither frequent nor massive. So you could think of this perhaps as maybe a de minimis type exception. So for ad hoc, one-off transfers that don't involve lots of people, don't involve lots of data, perhaps it doesn't involve lots of sensitive data, then there is a new exception that it would enable the controller to make its own determination of the protection that's in place, and if it's satisfied that overall that looks like appropriate safeguards and the data will be protected even after it leaves Europe, then the controller may be able to conclude that those data transfers can proceed. And what's interesting about that is that it's although overall the approach that's currently taken in the UK will need to change to come into line with the language in the regulation, this particular new exception under the regulation actually has many similarities with the approach that's currently taken uniquely in the UK, and so may have the effect of exporting to other European countries a little bit more latitude or leeway for controllers to reach their own conclusion as to whether a data transfer may proceed or not. So in conclusion, there are some changes. There are not significant changes for the better. It's still the case that there are restrictions on transferring personal data out of Europe. It's looking creaky as a solution even before the law is agreed and issued, in light of various technology advances that we've seen over the last sort of 10 or 15 years, but nevertheless that's what the law says. To the extent there's a chink of light that it's possible to identify, then it may be that the binding corporate rules process becomes more streamlined and somewhat easier and quicker for large multinationals. Thank you.